Yes, Mr. Bradley.
My Lords, we're now on to our ground 1B, which is, even if Your Lordship's relationship aren't with me on our ground 1A, we say that the particular acts of the UK government in this case bring the claimant within its jurisdiction because of the particular circumstances of the designation, i.e. the particular circumstances of the acts taken by the UK government, in particular because they have effects within the UK's territorial jurisdiction. And those effects target the marketable goodwill in the claimant's business, and that is a concept that doesn't depend on the company having a place of establishment, if one were to look at it that way, in the UK. To explain why I say factual, or the factual basis for this submission, the starting point is that the Secretary of State's entire purpose, and indeed its case, as to how the appellant's designation is justifiable, is precisely because it will have effects in the UK and out with the UK, and that those effects will detriment the goodwill in the claimant and the appellant's business. That is the intended mechanism of action. And I'm only going to take you to one document, and it's a document you've already seen, to make that good. That is the SDF, the revised decisions. That's the extant SDF. It's at Supplementary Bundle 3, Supplementary Bundle behind tab 3, page 62. Let's turn that up, please. So this is the Secretary of State's explanation for proportionality purposes as to what this designation is going to do. So the first thing it's going to do under the first bullet, and I'm not going to ask you to read it all now for reasons of time, but the first bullet says in summary that it will send the strongest message to international and domestic audiences that Dana Astra's conduct is unacceptable, and anyone involved with that conduct, i.e. the conduct here is its business, is not welcome to come or deal with their funds or resources in the UK. It's intended to have that effect in the UK. The next bullet, highlighting the purposes, by highlighting the unacceptable conduct in which Dana Astra is involved. And here, no, is involved, not has cause to suspect. This is saying that the government is telling the world that Dana Astra is complicit in the repression of civil society or domestic opposition or other actions that undermine the rule of law in Belarus. By telling everybody that is what the UK government thinks, that is intended to deter individuals and companies from engaging with or supporting them, or providing financial services, or making funds or economic resources available to it. Now, of course, that is something that can only happen within the UK, because that is the territorial reach of the primary designations, or by having actions on UK persons. It's the same bullet. Its mechanism of action is to should lead to criticism of Dana and their actions, and again, criticism of what the Secretary of State is publicly saying is its support for repression of civil society, etc., etc. And then, finally, for present purposes of cherry picking, in the time available, says that Dana's designation means that to the extent they would wish to deal with their funds or economic resources in the UK, this would be limited by their designation. Of course, that again only has effect in the UK. The undisputed evidence before the court below was that designation had in fact inhibited the appellant's ability to instruct its lawyers in the UK. The fact that a licence is available is neither here nor there for the question of whether there is an effect in the UK. Don't jump ahead to justification, whether there's a potential justification when one is concerned with the question of, is there anything that's actually happening in the jurisdiction? And it's positively relying on the fact that through these measures, the UK will be able to hold Dana Astra to account for the various actions that it says, wrongly, the reasons Ms. Lester has told you, a part of. So, transparently we say, it is the intention, indeed Secretary of State's case, that this will have these effects. Secretary of State's case isn't that this was all wishful thinking, because its case positively on proportionality is it's going to have these effects. It's how it's going to achieve the UK's objectives. And it achieves those both within and out with the UK. So what I say by way of my alternative submission, this is round 1B, is that when the UK has taken those actions within its jurisdictions that have effects on an individual, both within and out with the jurisdiction, the proportionality of those measures is something for which the UK government is answerable in convention terms. It has to justify and to make that good. And again, we're in the position of having to look at analogous situations, because for the reasons I gave before the short adjournment, one doesn't have a corpus of sanctions judgments. But can I ask you please to turn to tab 13 of the authorities bundle at page 937. This is the case of Vida and the United Kingdom. It's a case about interception in the United Kingdom of communications of individuals that are outside the United Kingdom. One sees the court's reasoning starts at paragraph 87. The point of principle that is of significance is at page 939 and paragraph 93. And could I please ask you to read that very quickly? So what the short point is, that what I say this stands for is the proposition, well established, clear and constant, because you see the references to the authorities that it's drawing on, that when a state takes action within its jurisdiction that has effects within the jurisdiction, it is responsible, in convention terms for that, it is within its jurisdiction. Even if the individual themselves or the entity themselves is physically outside the jurisdiction. And the judge rejected that. The judge said, actually, in A1P1 terms, it's different. That will only bite if you have goodwill in your business within the jurisdiction. And I say that is wrong as a matter of principle. Because it's no different, the situation in this particular case. What one is looking at is, are there effects within the jurisdiction, not where the individual, in Article 8 terms, or the company in A1P1 terms, is physically located. And that is extremely well established as a matter of convention law. The judge is the second strand, or really the building block to that determination of the judge.
Which paragraph are you referring to in the judge?
The judge's reasoning is at paragraph 64, which is at page 97 of the court bundle. So the other element of the judge's reasoning is really that what the claimant was concerned about, Appellant now was concerned about, was a purely reputational concern. It wasn't tied to an existing business in the UK or part of its recognised goodwill. And what that again boils down to is, if the entity was in business in the UK and had a goodwill, was trading in the UK, then I think the judge would have accepted that jurisdiction was established here. What he said was different is that because it was a foreign company, even though these effects were happening here, because the goodwill of the business was in some sense located offshore, because it was trading offshore, that wasn't caught. And that, in my submission, is wrong. And the central error, and it's one that I say is established by the authority set out in my skeleton argument, particularly Brea, is about what the distinction between goodwill and reputation is. Because of course it is now well established and all well known that a company's reputation itself is not a possession. What is a possession is the sort of bundle of business interests, if one can put it that way, that one takes. I'm aiming to do this in a few minutes, so I hope your lordships and your ladyship will apologise. I just give you the reference. It's Breyer in this court, decision of the Master of the Rolls, paragraphs 43 to 45, Authorities Bundle 20, page 1401. What the Master of the Rolls says there is that what is a convention right, what is a possession for the purposes of A1P1, is the benefit and advantage of the good name, reputation, and connection of a business, the attractive force that brings in custom. So it's when you have a reputation, that is part and parcel of a business, and that allows it to earn money, and it has a capitalizable market value, i.e. something you could market as a business and sell. That is a possession. And it matters not, in terms of what the Strasbourg Authority says, whether that business is in the UK or not. What one looks at is where are the effects of the state action felt, as your lordships have just seen. This is the UK, targeting precisely those aspects of the business by action in the UK. And they are acts, in my submission, that the UK is responsible for. They are within its jurisdiction for the purposes of Article 1. I've taken that very quickly in view of the time. You have that in more detail in my skeleton argument, but I think it's probably best if I allow Sir James to stand up.
Thank you very much. Anything else? Yes, Sir James.
My lords, my lady, we're going to split the advocacy, as I intimated earlier. I'm going to deal solely with the within the jurisdiction issue, and we're going to take that first, not least because it's a precondition to the application of proportionality, or indeed any of the articles of the Convention that follow. It's the foundational gateway through which you get into those substantive rights. Mr. Pobjoy is then going to deal with proportionality and rationality, and to spare my lord having to listen to me again on Schwidler, and what that entails, to the extent that needs to be dealt with at all. And then Mr.
You might cut him short on Schwidler.
You might cut him short, well, in which case it'll be short, but he's going to deal with proportionality. And then Mr. Thackeray has got some, perhaps got some very brief submissions on grounds 2, C and D, arbitrariness and retrospectivity, although they were hardly touched upon already. That's how we're going to do it. So within the jurisdiction is me. That is a concept which, if you take up the judge's judgment and you go to paragraph 47, as he correctly acknowledged, has been the subject of repeated Grand Chamber decision-making. He lists the main ones in paragraph 47, or the main recent ones, but you will see as the judgment goes on that there are others, almost all of them in the Grand Chamber, and if I wanted to add 2 very specifically Grand Chamber decisions to that list in 47, you would add Bankovich, all those years ago, which I argue with Christopher Greenwood, and Duarte Agustini, which is the one about in the environment, which is in the bundles, and I'm going to go to. But very frequent consideration by the Grand Chamber in a succession of cases. The question, as my lady correctly put to my learned friend and he ultimately accepted, is whether the person is within the jurisdiction. This isn't jurisdiction in the sense of it being just ordinary UK jurisdiction or not. Is the person, because the obligation under Article 1 is to secure to everyone the rights and freedoms if they're within the jurisdiction.
But it is theoretically possible for a government to bring a person within the jurisdiction by exercising their jurisdiction over it.
Yes, that's possible.
Yes.
In certain circumstances, and the question is when.
Yes.
And that's what I want to make submissions about, because that concept within the jurisdiction, considered frequently in those cases, many of them relating to military operations abroad, ours in Iraq and in Afghanistan, which there was lots of argument about attribution, a separate set of arguments about attribution as well. We've seen some of that in NADA and Switzerland already this morning. But lots of decisions of that kind. And the basic point is that it is a proper term of art, or a proper concept of art. And its meanings and its limit have been considered and now set pretty clearly by the Strasbourg court. It isn't simply to be equated to any exercise of state power.
There's never been a sanctions case.
There's never been a sanctions case which is, I think as we all agree, which is considered the question of jurisdiction.
No.
And I'll come back to that for obvious reasons when in the very concluding part of the submissions, which are going to be related to AB and the Secretary of State for Justice. Clear and consistent line of authority, domestic courts being fully confident, the IOOO principle and all of that, but I can take that pretty shortly because it'll be very familiar to the court. But it does reinforce the importance of that and underpins that principle, not just because the government can't go to Strasbourg from its own courts, but also because of the breadth of the ramifications. If my learned friend is right, pretty much any sanctions case, any state action case which has effects on people outside the jurisdiction, irrespective of whether they're outside, all their assets are outside, and everything happens outside effectively, all of that would come within the jurisdiction.
But your argument is, even if it might be, it isn't yet, and we shouldn't get ahead of ourselves.
My Lord, that's the fundamental submission, but I do want to take you very briefly through some of the arguments just to show you how that concept works, to reinforce that point, because the basic submission I'm going to be making is, here are the basic principles established by the case law. We all agree that judgment paragraph 48 effectively sets them out. And in the briefest possible summary, it's primarily a territorial concept, but, to go back to the yes answer I gave to my Lord a minute ago, there are circumstances where it can have extraterritorial application, obviously through the exercise of some form of state power. And the question is, what are those exceptions?
But I mean, to cut to the chase, paragraph 113 of MN, if you read it, you could answer the question, does sanctions of this kind fall within the ambit of that sort of obiter dictum of the Strasbourg court? Answer, yes, possibly.
Well, my Lord, I would say not even possibly. And the reason I say that is because the exceptions that have been built up to the primarily territorial operation of this article, the exceptions that have been built up start with control over an area, effective control over an area.
Yes.
Russia goes into Transnistria or some other satellite state and takes over the functions. We're not worried about that.
No.
There's a third one, which the judge refers to in paragraph 48 as well, about diplomatic and consular activities over your own nationals abroad.
Yeah.
We're not within that.
Yeah.
So the question is, and the question is normally in these cases, what are the limits and what is the nature of the state agent authority and control principle? That's the one that sits in the middle between effective control of an area and diplomatic and consular. There's a very limited separate one, which is hardly an exception at all, which relates to procedures that are happening in your own country. Mm-hmm. So that if, for example, wherever the thing that is being litigated about might have happened, if, for example, there is a civil case being brought by people who are injured abroad, for example, by the activities of your forces, and that's brought in the domestic courts.
Article 6 applies.
Article 6 applies, and you've got to be fair. Likewise, and by extension, similar sort of thing, if you have events that happen abroad and someone dies, and you launch a criminal investigation in your own country, that is a sufficient link to bring you within Article 2 procedural.
I mean, the point I'm putting to you is that there is nothing in any of these authorities that deals with this situation.
My Lord, there isn't.
Or makes an exception for this situation. But some of the language that is quite expansive, used in MN, in quite a different and inapplicable situation,
might be read literally to do.
Might be read as meaning that this would be another exception. But your point is, the court has never said so. We shouldn't overreach ourselves, and you can't go and establish that it is not the case. And that is much more important for a government than it is for an individual, because they're only going to have one sanction against them, very likely, whereas you may impose loads of sanctions. So you submit we should leave it to Strasbourg.
My lord, I do, but without wishing to quibble unduly with my lord.
I'm used to it.
I know, but I'm not quibbling, I'm just adding. This is an addition. So the 113 paragraph that I know is in your head, the 113 paragraph refers to authority and control. Those are the words which could be read relatively broadly, at least on one reading of them. Mm-hmm. But my point is that those words are about state agent authority and control, and the case law is absolutely clear that they refer to authority and control over the person, over the physical person. They aren't just exercises of state authority. They aren't just exercises of state power.
No, but what about a corporate person?
Well, it could be a corporate person or whatever impacted. But the point is that if it's state agent authority and control, it has to be authority over something physical. You can have it on buildings. There are some cases where people have been held on ships, for example. Some cases where people have been held in buildings. Some cases where people have been held in custody. Mm-hmm. But that expression, state authority and control, is not a pseudonym for the exercise of any form of state authority in the expansive sense. It's a much more limited idea that goes to the control of the person. I'll give you one example. Bankovic itself. Mm. You'll remember the facts of Bankovic. Bankovic was about the bombing of the television station in Belgrade. Yeah. And the victims of that bombing, or the families of the people who were killed in the bombing, basically took to the European Court of Human Rights all the countries in the Council of Europe that had been members of NATO. It wasn't clear which nation had actually dropped the bomb out of its plane. Didn't matter. All the Council of Europe states that were members of NATO were sued in Strasbourg. And what the Strasbourg court said was that the people who were killed by that bomb, dropped by, let us assume, a United Kingdom plane, were not within the jurisdiction of the United Kingdom. And they were not within the jurisdiction of the United Kingdom, even though, and this was an argument specifically run and rejected, the decision to launch the mission, and thus to drop the bomb on the television station in Belgrade, had, for the sake of argument, the facts are still shrouded, but for the sake of argument, had been taken in a contracting state. So what that case illustrates is that this is not merely not a doctrine of effects, as they put it in the jargon, but it is not a doctrine which brings someone who is outside the jurisdiction within the jurisdiction simply because the state acts in a way that might be thought otherwise to interfere with their convention rights or causes deleterious effects for them. So
sorry.
I'm so sorry, my lord.
Suppose the person isn't within this jurisdiction, but the person's possessions are.
Well, my lord, that may be a more difficult question, and that is why the judge, I think, was particularly interested in whether or not the goodwill was within the jurisdiction, because the goodwill of companies, as we know from that difficult A1P1 distinction, which you'll be well aware of, goodwill is treated as a species of possession, whereas future income, that's the distinction, is not.
Future goodwill, I mean, it's a very weird idea that you could say that this company, which has never traded in the United Kingdom, has goodwill in this country. I mean, it probably has, in that sense, it has goodwill everywhere.
Well, my lord, that was essentially the reasoning of the judge. He says, well, whatever goodwill may mean, you're on the wrong side of it.
I mean, I'm very interested in the point you made, explaining why the words authority or control in that dictum, because you're quite right, those are the words that concern me, mean something rather special.
My lord, I was going to take
you might need to go to Bankovic and subsequent cases.
Yeah, I was going to take
all that much time. So
no, I was going to take you to 3 cases only. I mean, you've had the headlines of the submission.
Yeah. So I'd like just to see it, if you could.
Can I just pick it up first of all in the judgment at paragraph 48.3?
Yeah.
Look at the final sentence, where he's specifically dealing with 113. over them, which is consistent with that. So this is both it's a positive point about it needs to be physical control or authority over the individual, and it's a negative point that says it isn't just a doctrine of effect, so it's whenever the state exercises its power. Go to Bankovich first, if you would.
I'm sorry to bang on about it, but my, possibly commercial reading of exercising control over a person or a whole area outside its territory, you do in a commercial sense exercise control over a company if you do it damage by let's assume you do by sanctions legislation. So it's got to mean something rather more specific.
Well, you do exercise control and authority, at least on one commercially minded view of that phrase.
Yes.
If a person turns up at your embassy and says, can I come in because otherwise I'm going to be subjected to Article 3 ill treatment, and you exercise your state power to say no, you're exercising state power.
So you say there's no...
The point is they're not within your jurisdiction on that basis. That's why I tie it to the negative side that says it isn't a doctrine of effects. One can put the same point in a slightly different way. It does not mean, it does not equate to the exercise of state power. State power was being exercised in MN by refusing them entry to Belgium. State power was being exercised in Bankovich by taking the decision to launch the mission, say it was done in London, and the bomb then gets dropped, which kills people. They're not within your jurisdiction. It isn't the exercise of state power. It isn't the causing of an effect. And what is required in this context is the person. So you can understand why we had the endless debate of it in the context of Iraq and Afghanistan. And there were Court of Appeal judgments. Lord Justice Lloyd Jones, he then was dealing with, in a case called Mohammed, dealing with that difficult distinction. When is someone shot and when is someone killed in your custody? But there's a clear line there. The custody person is within your jurisdiction. The shot person, like the people unfortunately bombed in Belgrade, are not. And what's the explanation for that? It's not a doctrine of effects. It is a doctrine when you come to this exception, state agent authority and control. It is a doctrine which requires you to be in charge of the person, effectively. Can I invite you to go to Bankovich first of all? I just want to explain how this works. So you have the basic conception in your head. You've got primarily territorial. You've then got some limited exceptions. And as I say, in the case law from Alskany onwards, they are effective control of the area, state agent authority and control, some limited procedural things which are explicable on the basis that the process is happening in the country, and diplomatic on your own nationals. Those are the four that have been acknowledged. And what effectively Strasbourg has done is to stick to those. There are frequent references in the case law to exceptional circumstances and all of that, and links and so on, but this isn't a free-for-all. That's the significance of Agostini, because in Agostino, they say, well, it's not just a free-for-all. You can't just say exceptional circumstances. It all depends on the length of the Lord Chancellor's foot. It all depends on how the court feels when it's confronted with a set of facts. You have to bring yourself within the established exceptions. And there's a jolly good reason for that, because this is a foundational provision. This is the gateway provision. And so it isn't the sort of provision that you'd expect to be susceptible, for example, to a living instrument or anything of that kind. This is what the state parties agreed to, and only agreed to in terms of the door being open for their responsibility.
So you go further, really, than I was putting to you. You say, no,
just a little.
There are established exceptions. This is actually not an established exception.
I do.
It could fall within some loose language, but we don't have a doctrine of obiter dicta anyway in Strasbourg. And they have clear exceptions. This is not one of them. Leave it to them.
Leave it to them. That's essentially...
And they might establish one, but you say
they might.
Actually quite unlikely.
Yes. That's the only addition. So it wasn't really a quibble. It was just just so you didn't lose sight of what that state agent authority exception.
I mean, so far as I'm concerned, and I don't want to stop you dealing with all the other points, and I don't know if either Lord Justice Bean or Lady Justice Laing is going to object. You could take these cases. We're familiar with these cases, and you could go to the bits you really want. Quite quickly. Is that okay?
I'm only going to go to three, and very, very briefly. Bankovich first, tab 2, page 33.
Well, we know what Bankovich was about.
You know what Bankovich was about? That was the dropping of the bombing on the...
Dropping of the bomb, yes.
So, doctrine, not a doctrine of effects, paragraph 75. And really, you can pick it up 5 lines into 75. The governments, of which the UK was taking the lead, as I've explained, the governments contend that this amounts to a cause and effect notion of jurisdiction, not contemplated, and so on. Next subparagraph, the court is inclined to agree with the government's submission. Text of it does not accommodate such an approach to jurisdiction. So that's the establishment of the principle. This isn't a doctrine of effects. What was being said there was, they had the power to kill us, and they killed us. That must be enough. Answer, no, it isn't. And that demonstrates that that ability to affect an individual's human rights, that ability to cause harm or prejudice is not sufficient. So that's 75. I wanted to pick up one other point from Bankovich, which is that an attempt was made in Bankovich to say, well, hang on a second, the decision was made, let's assume, in the United Kingdom. And as a result of that decision, we were killed outside the jurisdiction in the television station in Belgrade. So that's very similar to Suring. Suring being the case that says if you move someone out of the jurisdiction and to a risk of Article 2 or 3 ill treatment, the state is responsible. The difference, of course, which is where the court finds itself on in Bankovich, the difference, of course, is that in a Suring situation, the person is in the jurisdiction. They're physically here and you're removing them. So you see the argument being mounted at 53 on page 26. And that is then rejected at 68, para 68. And you see the explanation for it in the second sub-paragraph of 68 at the top of page 31. So you have the facts of Bankovich. I say Bankovich is important because it establishes it's not a doctrine of effects, and it establishes it's not, authority and control is not about the state simply exercising its power.
And I'd forgotten it was an admissibility decision.
It was admissibility, but only because they took the point on jurisdiction at that stage. It isn't a manifestly ill-founded thing.
No.
It's jurisdiction on the merits, and it's Grand Chamber. First of many. MN, then, very briefly. Tab 10, page 561, it starts. The key passages and the key reasoning of the court, which we invite you to read now. Hopefully I've made the submissions on the themes. I hope when you reread it, it will chime with them. The basic passages are all sidelined for you, and you need to read that as a whole to get the sense of it.
Yeah.
But just to pick up a couple of points from that, you will see that they set out the primarily territorial principle, paragraph 98. You will see the exceptions being referred to in 101. And you will see exceptional circumstances being referred to in 102. I'm going to come back to that because it's explained what that means in Agostino when we get to it. 103 is effective control over the area. That's the first of the Alskany exceptions, so we don't need to trouble about that. 105 is about control and state agents operating outside the territory. And you see the way in which that is put. The significance of that is that those are all about control over physical things. Normally the person, so it's state agent authority and control over the person, means actually over the person. It doesn't just mean the exercise of state agent authority in the broad sense.
Through control over buildings, aircraft or ships in which individuals were held, exercise power and physical control over those persons.
Exactly. That's the key point.
Yeah.
That's the key point in relation to that. And the third one I mentioned, which was diplomatic or consular officials over their own nationals, that's 106. Yeah, so they're revisiting these basic principles. And then 107 is of some importance because those are what I call the procedural exceptions, and they're not really exceptions at all because the proceedings are happening here, so it's not surprising they attract the fairness guarantee in Article 6. And if criminal investigation is launched, it's perhaps not surprising, although more controversial, but perhaps not surprising, that engages Article 2 procedural. Doesn't engage everything. And we know that it doesn't engage everything because you have Abdul Wahab Khan dealt with in 108. And that was a case in which the person concerned had been removed or had gone from England to Pakistan and had then had their right to return or their nationality, as it were, whatever, whichever one it was. They were stopped then from coming back to the United Kingdom. And they said, well, hang on a second, we're now in Pakistan. You've taken action unilaterally as a state to shut us out from coming back. And we're being subjected to Article 3 ill treatment in Pakistan. So that's your responsibility, and not a bit of it. They were outside the jurisdiction. That was the risk that they were facing out there, no jurisdiction.
And that was the argument we were having in IA.
That was the argument you were having in IA, one of them, exactly. And so then one comes to the application. Those are just the general principles. That's the structure up to the end of 109. It's all recitation of the general approach, primarily territorial, various exceptions, and so on. An application to the present case at 110, and you'll see the way the argument is put in 111 by the applicants in that case. Just have a look at 112. They took the decision for entry into the Belgian territory, and in doing so exercised public power. So they acknowledge all of that. They're exercising public power by refusing them entry. I'm at 112 in the judgment of page 586. In itself, however, this finding is not sufficient to bring the applicants under Belgium's territorial jurisdiction within the meaning of Article 1. The mere fact that decisions taken at a national level have an impact on the situation of a person resident abroad is also not sufficient to establish jurisdiction, and so on. See Bankovich. You'll remember paragraph 75. Yeah, so you see the way this is all working. And then you get into 113, but now you understand when they say effectively exercised authority and control over them, that's the chime back to the paragraph that we looked at earlier at 105. It's the physical control point. And you'll see the basic approach that they then adopt, which is to say, well, can you bring yourself within one of these categories of exception recognised in the case law? If not, you're out. Look at 118. None of the case law precedents are applicable to the present case. Contains none of the connecting links which characterise the above-mentioned cases. And then they draw exactly the same distinction that was drawn in Bankovich about any attempt to try and analogise with the Suring principle in paragraph 120. And then the procedural exception is basically dealt with in 122 in now familiar and clear terms. So that's the way it worked in that case. If you jump forward then to most recent, one of the most recent Grand Chamber decisions on this, this is the environmental case of Duarte Agostino. Tab 14 starts at page 945. And you'll see that what happened in that case was that basically 6 Portuguese nationals sued all the Council of Europe countries for creating climate change and exposing them to risks to their health.
This followed the Claimant Signoria and Switzerland case, didn't it?
Yeah, I think it did, that we may have looked at in the context of Friends of the Earth all that time ago.
Yes. But it refers to it in 7.
Yeah. My Lord, you see the basic facts and the complaints from paragraphs 12 and 13 on page 947, bottom of 947. It just gives you a sense of the nature of the argument. And then they come to deal with jurisdiction at page 993, starting at paragraph 168. And if you were going to read, as it were, the various bits that that help on jurisdiction from the Grand Chamber, it's probably this case in MN that will do it. But you'll see at 168, they cite very extensively from MN and Belgium. Look at para 168 at the bottom of 993. That citation from MN goes all the way up to the bottom of page 996. And they've cited the entire section that we've just been through.
Right.
And you see what they emphasise in paragraph 169.
Yeah, but the question is bottom of 996, top of 997.
Yeah. And then they cite extensively from the Ukraine and Netherlands v. Russia case at 171. Including, for example, on page 1000, towards the top of the page, within the citation from Ukraine and Russia, paragraph 571 at the very top of page 1000. In all cases of state agent authority and control, any jurisdiction establishes a personal one over the victim. And then they come back to state agent authority and control in 182. And you'll see what they conclude in 182. I'm hoping that reinforces the point I made earlier on about it needing to be personal over the individual.
182.
182 at the bottom of page 1003, para 182, starts in terms of the usual situations. So even though in this case they were saying, well, look, our health has been terribly damaged, you created these conditions, there's an awful deleterious effect on us because of your failures, none of that worked under state agent of authority and control because they weren't under the authority and control in the requisite sense for the purposes of Article 1. And then go to 184, which is of some interest. The court begin by reiterating it's consistently rejected the idea that the fact of a decision being taken at national level which has impact on the situation of a person abroad could in itself establish the jurisdiction of the state concerned over the person. You see that in 184. And they cite MN and HF and France. And then applying the approach that I mentioned earlier, are you in the case law or aren't you? Look at 185. Same reasoning we've already seen. If you're not within the case law, you're in trouble. And then a point of some importance, because one's seen various references to exceptional circumstances, look at 188, emphasising that exceptional circumstances does not indicate that it's a free-for-all. Not a distinct jurisdictional test, as they put it. And then you see the final sentence of that paragraph. In other words, the assessment was ultimately one of effective authority or control over the applicants in line with established case law. And then they conclude that the various things that were relied upon as links do not work to create the requisite jurisdictional link, and they cite lots of case law with which you'll now be familiar. Just pick it up at 199, without troubling too much on the facts, page 1006, last sentence of 199. In this connection, it's reiterated that jurisdiction cannot be established merely on the basis of the argument that the state is capable of taking a decision or action impacting the applicant's situation abroad. And the reason I highlight that is because that was the passage cited by the judge at paragraph 49 of the judgment. And we respectfully submit accurately cited.
Yeah.
The other bit that was accurately cited, again, we respectfully submit, is the passage at 205, first sentence, on the next page, 1007, as regards their reliance. Control over the person himself or herself, rather than the person's interest as such. Do you see that?
So which paragraph?
It's paragraph 205, my lord, first sentence.
Yeah, got it.
So not merely is that emphasising control over the person himself or herself, but drawing a distinction between that situation and the rather than the person's interests as such. That was the second passage cited by the judge at paragraph 49. So, my lord, my lady, those are the cases, and as we can now see, the attempt to rely upon any sort of procedural exception, as it were, simply doesn't wash, because we know
that's critical to 205.
205 is
because it says in terms it requires control over the person himself or herself
rather
than the person's interests.
Yes.
And what you would be talking about here is control by affecting cause and effect on the person's interests.
Yes.
So it's rather you just have to read it quite carefully to understand, because the words used could, as I said before to a poor, ignorant commercial lawyer, mean what they're supposed to mean. But when you look at it more carefully, you say, no, that's exactly the opposite of what it means.
That's exactly how I do it. It isn't just state authority, the exercise of state power. That would be inconsistent with it not being a doctrine of effects.
And incredible ramifications.
Incredible ramifications, and not within the state agent authority principle.
And then Ms. Lester says, well, that's right, but it's terribly long-arm jurisdiction you're exercising against millions of people abroad who now can't challenge any of it.
Well, they can challenge it. They can challenge it on domestic law grounds. They just can't challenge it under the convention.
That's not very easy for all the reasons that you're going to be, or your colleagues are going to be arguing in a minute.
Maybe so, but that's a matter of domestic law, and that was the position at all points up till October 2000, when the 1998 Act was brought in.
Okay.
But that's how we put it anyway. I hope that exegesis has been a bit helpful anyway. My lords, I can skip then, I think, to NADA, and I'll take that very briefly. You have the short point on NADA. You cannot possibly say that the court can be remotely, let alone fully confident, which is the phrase in AB, as you remember, AB and Secretary of State for Justice, paragraph 57, and doesn't represent a clear and consistent line of case law, if the case doesn't even consider the issue. And the fact of the matter is that we can see from the argument, and my learned friend Mr. Birdling eventually accepted, that NADA and Switzerland is about attribution. So not merely in all those Iraq, Afghanistan and other cases where there are arguments around, and indeed in the sanctions context, where there are arguments around jurisdiction, but there are also arguments about whether or not, when the UN requires through the Security Council states to do things, are the things that are then done attributable to the UN, or as it were, the executing state? That's the issue that's troubled them in a variety of different contexts, and they produce different answers on the facts. But that was the debate in NADA and Switzerland. It was a debate about attribution and not jurisdiction. So you can argue uphill and down dale about what the right answer might or might not have been on jurisdiction. The issue before the court, and the only issue before the court, was one of attribution. So NADA simply does not assist.
Yeah.
So far as goodwill is concerned, we respectfully submit, again, that my learned friend drifted, and he has to drift, to saying, well, what matters for jurisdictional purposes is that there are effects, as he kept putting it, in the jurisdiction. That is not the principle. Within the jurisdiction is not, expressly on the case law, not a doctrine of effects. There is no case in the sanctions context or otherwise that simply says you're within the jurisdiction if there's a possible effect within the jurisdiction of your country. So that is not the principle. There might be an argument, and as I say, no case has even yet determined this, where if you actually have assets in the jurisdiction and those are affected, that in itself might be sufficient to create the requisite jurisdictional link. But we are not in that situation here for all the reasons we discussed earlier. The fact of the matter is that this company has never traded in the UK, doesn't look as though it's got any particular great intention of trading in the UK. And our respectful submission is that the judge, in considering the principles and their application, i.e. the principles, that distinction between future income and goodwill, difficult though it may be, and its application, which may be easier, because however you cut the fineness of that distinction, it doesn't matter for present purposes, so his application of it was exemplary. We respectfully submit that that part of the judgment is self-evidently correct. He dealt with it between paragraphs 58 and 66. So that's what we say about goodwill. The reason my learned friend had to take on that burden was in an implicit recognition, at least below, that he had to demonstrate some form of asset here, and there isn't one. And that was what the judge concluded. So the final punchline and the final position is we do submit that it's pretty clear, applying the correctly identified principles in the long line of Grand Chamber case law, that this company is not within the jurisdiction of the United Kingdom. But even if there was doubt about that, my alternative submission would be you can on no view be confident, not merely that there isn't a clear and consistent line of case law to this effect, but you cannot be fully confident. That's the phraseology from the Supreme Court, repeated twice in that same paragraph 57 of AB, which is behind tab 21 in the authorities bundle, page 1441. It's too well known to turn it up. And we respectfully submit that all of that need for domestic caution is given added weight by the fact, or by two facts perhaps. One, this is about Article 1. And Article 1 is foundational. And so by definition is super important because it's the gateway into the obligation that is then assumed by states to secure to everyone within their jurisdiction the rights and freedoms in the Convention. But secondly, because in the specific context of sanctions, and one wouldn't necessarily limit it only to sanctions, because on my learned friend's logic, it's an argument about effect. It's an argument about wielding state authority. The ramifications of a decision that this company does fall within the jurisdiction on the facts as presented would be very, very significant, which at the very least is another good reason for this court not stepping, put it the other way around, for this court not confining itself well within the well-established four corners of the Strasbourg jurisprudence and not stepping beyond that. So that's how we put the argument on jurisdiction.
And goodwill is neither here nor there.
Goodwill is neither here nor there on the facts. You don't have, I mean, sometimes, and we've had this discussion before, my lord, as you know, it's a difficult and in some respects an unsatisfactory distinction, even though they've drawn it between future income and goodwill, because the two tend to blend into each other. But it doesn't really matter on the facts. My respectful submission.
So, if there were business of Dana in the UK, existing business, and therefore there was established goodwill attracting custom to their business in London, then the whole position would be different because it would be a Schwidler case where...
Well, it might be.
It might be.
It might be. I mean, it's not an issue, mercifully, which you have to grapple
with. This is a sort of allegation that the goodwill is international.
Goodwill is international and exists everywhere.
Yeah. Okay.
That's how we put it. So.
And that it floats free of any actual business in the...
Any actual business. And we know that the basic conception of goodwill in Strasbourg terms is current marketable. It's a current marketable thing that you can capitalise, that you can sell.
Well, you say...
Plainly not.
That's future income writ large.
Yeah, I do.
Even if you have the intention of setting up here.
I do, because the nature of the obligations are personal on people who would otherwise be dealing, so they can't generate that future income. That's the nature of it.
Good. Well, is that you?
That's me done.
James, thank you. Mr. Pobjoy.
My lords, my lady, I propose to take my submissions in 5 parts. I promise the first 2 parts I'll deal with in less than 90 seconds. Part 1 is going to be the approach to proportionality as set out by the Supreme Court in Schwidler, 30 seconds maximum. The second point I want to deal with, maybe in 60 seconds if you allow me, is the distinct Schwidler appellate point and whether or not you're doing this fresh or not. The third thing that I want to spend a little bit of time on, hopefully no more than 10 minutes or so, is just to take the court through the key decision-making documents.
Yes, please.
You've jumped in and out of a few of them, but I think it's very important that you see the full picture, and hopefully they're scattered not in chronological order between the 2 bundles. So I'll go through those carefully for you.
Thank you.
The fourth thing I'm going to do is address proportionality, explain why this decision was clearly proportionate by reference to the judgment, but also the underlying evidence. I hope you understand, notwithstanding how the argument has developed today, why I'm going to deal with that first. There's a very full attack on the proportionality reasons of Mr. Justice Saini in the skeleton, only a paragraph on rationality. So I need to respond to it. I'm going to respond to it. And in responding to that, then once I get to the final part of my submissions, part 5, rationality, it will be perfectly understandable why the judgment is structured in the way that it is. And I will, of course, respond to the specific points made on rationality. But you'll see that the points are made are just not a fair characterisation of the judgment. So I'll deal with that last, but I am going to respond to the points.
But actually, there's more than 95 on rationality. I was looking at it. There's 29 onwards earlier on, which deal with it.
Yes, that's right.
It is sort of cut up a bit.
But just to explain that now, just to get out of the way, below there was also a standalone argument that on the civil repression point, that it was irrational to even conclude that they were an involved person. So that's why rationality is dealt with under that head. Now that is not live in this appeal. We're just concerned with part 2, discretion, if that makes sense.
Yep.
So that's the structure. Part 1, approach to proportionality. I'm just going to give you some references. We don't even need to take it up. First key point, it won't surprise you that I'm going to make, is deference. That's paragraph 126 to 130 of Schwidler, just making it very clear that in the sanctions context, particularly when you're concerned with predictive and evaluative judgments, and they really call out rational connection here, you have to give considerable deference to the judgments of the executive. That's the key point that I really want to take. Everything else in Schwidler will be very well known to the court. Schwidler was, of course, handed down after Dana, but what you see at paragraph 70 and 73 of Mr. Justice Saini's judgment is that he was applying the principles that this court set out in Schwidler.
The bits that were upheld.
The bits that were warmly endorsed, I would say.
Warmly endorsed.
Okay, so that's the approach to proportionality. Section 2 of my submissions, part 2, appellate function.
We are duly admonished, and we now understand.
Yes, well, but can I say here, in this case, I respectfully disagree with Mr. Birdling, and I will just take up one paragraph of Schwidler. It's paragraph 148. Yes. It's at 1632 of the second bundle.
1632.
Page 1632, para 148. Mm-hmm. And really, so it's starting with the second sentence. The question of proportionality of measure may have wide significance on the first occasion it arises, but then the relevant determination may be made at an appellate level and the answer to be given in general terms becomes clear. On the next occasion the issue arises, the circumstances will be materially different, etc., etc. And we say we are squarely within paragraph 148 in this case. The sole answer, and this is an important point of principle, which is why I'm going to have my 60 seconds on it. The sole answer that's given is, well, no, we've come up with a distinct point here on jurisdiction. Jurisdiction is an entirely distinct legal issue. There was nothing in my learned friend Ms. Lester's submissions that suggested that the approach to proportionality should in some way differ because there are no assets in the jurisdiction. That's all relevant to the question of whether jurisdiction is engaged, but it has nothing to do with proportionality. This is just bog standard proportionality applying Schwidler. So we say it is the traditional review function.
The approach might differ for the reasons the judge gave, which is there are no assets in the jurisdiction, what do I put in the balance?
Well, quite.
But that's a separate point.
That is a separate point. Okay, so the decision making. There's no dispute about kind of the chronology in terms of there was an original EU designation which had direct effect. Then the claimant was autonomously designated. What really matters for our purposes and where we should start in the chronology is the 16th of February 2023, where the claimant exercised its right under Section 23 of SAMWA to have a ministerial review. It submitted as part of that application a bundle, I think it was over 3,000 pages, most of which was before the court below, of witness statements, expert reports, documents, and asked for a ministerial review in relation to the designation. A comprehensive review was undertaken. This is described at paragraph 24 of the judgment. For your note, it's also set out in the witness statement of Mr. Darling at paragraphs 36 to 47, which is supplementary bundle 99 to 102. And as part of that ministerial review, 3 key documents are produced. So I'm just going to show you those 3 key documents. The first is what we've been referring to as the amended SDF, or amended sanctions designation form. This is a form that's created in every sanctions case. And this is at supplementary bundle 48 it starts. Just to avoid confusion, just for your notes, so there is another version of this behind tab 1, starting at page 3, but that was for the original designation. The one that starts at paragraph 48 is the version that was produced following the ministerial review. And just going forward to paragraph 50, page 51, you see here the designation criteria is set out, and what is always done in these cases is that the officials will highlight those criteria that are relied upon. There's no dispute about that, but we do emphasise 6A is or has been. You then, if we go to page 54, you have the evidence summary, and what we have here is it sets out the 2 grounds for designation. The first ground starts at 54, the second ground starts at 58, and it describes in detail all of the evidence that goes to that particular ground. And on no view can that be suggested, I think this was the submission, that this is just some tick box exercise to get through a gateway. There is very detailed consideration of all of the evidence. All these exhibits, I should say, refer to what's called as a sanctions designation form evidence pack. Now, you don't have that in the bundles. It was in the bundles below. And so all of the reasons that officials consider that that first criteria is satisfied. And then the second ground starts at page 58 and goes through to para 60. You can see in this sanction, I think my learned friend suggested there was nothing in this sanctions designation form that suggested it's has or is. We can see at the top of page 60, this is specifically in relation to obtaining a benefit from or supporting. Couldn't be clearer, has or is. So that's the grounds. So it goes well beyond just some tick box. And then you get to part 3, which is why, with the caveat, assuming the convention applies, why this is a proportionate decision. And it goes through the bank mallet criteria in extensive detail over the next 8 pages. And we say all of that, even though that's done under the heading of proportionality, and I entirely agree with comments my Lord made about the importance of separating it out, what you can't do is to say that all of that is irrelevant to the question, for instance, of whether or not this is a rational decision. This is all stuff that was considered by the decision maker in justifying the designation. You can't silo it off in that way. So, and you then have other impacts addressed at 65. So that's the sanctions designation form. At the same time, you have what's called the administrative review form. That's in the core bundle at 132. And what this document does, and again, this is produced in every case by the Foreign Office where an administrative review is requested, is it sets out all of the arguments that have been made by the designated individual or entity and and provides answers, if there are answers, to those criticisms. So at para 133, it summarises all of the points that are made. It then sets out all of you can see the huge amount of information that was considered. And then from para 139 onwards, you see a very detailed answer to many of the points that have been raised today. So claim 2 is about the fact that there have been hostile actions taken against the applicant in Belarus. You have claim 4 is the fact that other Western companies continue to sponsor the NOC, etc. All of the arguments that have been run have been carefully considered and answered. Again, this is not a tick box.
You say this is all part of the exercise of the discretion?
Absolutely, absolutely. You can't silo it off in the way that has been suggested. And this all goes both to rational connection in terms of proportionality, but also just why this decision is rational. Absolutely. If we then go to 143, you see what happened as a result of this administrative review exercise. There was a change to the statement of reasons, and that is set out here. And you can see very clearly, sorry, at 143, under the proposed amendment, number 2 is or has been. This was the document we were trying to find, my lord, earlier. But my lord, if you got it, it's in the first column next to the 2. You see is or has been involved in obtaining a benefit. So this form is produced. What then happens is that there is a meeting of officials. That's in the supplementary bundle at 196. Bad reference. 1 second. Yeah, oh, sorry, it's at 168. 168. 168 of the supplementary bundle, 16th of August meeting. They call this an administrative review case closure panel meeting.
So is that 16th of August?
16th of August.
Yeah.
My apologies, my lady. And my learned friend took you to 169, paragraph 4, saying following discussion, the panel concluded that the appellant satisfied the test, that he was an involved person, and that it was proportionate. I think it seemed to be suggested that we should have had another sentence there, kind of saying, and the decision was otherwise rational. Now, the suggestion that you need to kind of tick that box expressly, we say is just unsustainable. That it's built into, he was an involved person, and into that is all of the analysis that's been done as to why they're an involved person, why this is proportionate, etc. But in any event, even if that wasn't enough, have a look at paragraph 6, which my learned friend didn't take you to. The panel considers that the designation remains justified on policy grounds and was rationally connected to the objective. We then have...
There does seem to have been a little bit of a mix-up of the concept of proportionality and the exercise of a discretion.
Well, that's fine. But what this court is concerned with is whether the decision is rational.
Yes, but the use of the word proportionality only is relevant,
yes,
really, if the convention is engaged. And that is section 3 of the document you showed us.
Yes.
Which assumes engagement of the
yes.
convention. But this bit is not actually tackling the convention issues. It's tackling should we maintain the designation.
Well, because they will only maintain the deputy, because it's at this stage they're assuming, out of an abundance of caution, just in case Article 1 is engaged, so that they are assuming that it's proportional. So they are here saying, at paragraph 4, they are saying, effectively, they're an involved person, and we say, and the exercise of discretion is rational, and it is proportionate, open brackets, if Article 1 is engaged, if jurisdiction is engaged.
I completely get all that.
Yes.
And I'm not really, I'm just, and you can't expect government to look at it from the point of view of a challenge to the decision.
Exactly.
When the government makes decisions, it doesn't say, am I making a rational decision? It makes a decision on a proper basis, one hopes, taking into account the right things, not taking into account the wrong things, and then waits for somebody to say, that is irrational. Yes. Right? And so it doesn't have to say, I'm making a rational decision, that's ridiculous. But proportionality is a different concept altogether. It is about, I mean, I understand that it brings into play some of the same concepts and ideas as we see from Bank Mellat itself. But all I'm saying is government actually doesn't have to use words in a technical legal sense, provided it's considering the right things at the right stage. And what we're seeing here is that it used the word, I mean, proportionality is a word probably I think should be banned myself, because I don't even think it properly describes the concept that it's supposed to mean. But anyway, everybody uses it in a public law context, including decision makers,
yes,
which is pretty unhelpful. But so long as we understand what we're looking for when deciding whether A, the decision is rational, and B, if you're looking to the convention being engaged, whether proportionality is established.
But there's perhaps a further point which the judge recognised, which is that if the decision maker has subjected its own decision to a proportionality review, it has subjected it to a higher degree of scrutiny than reasonableness of common law. So that's really the point the judge was making.
I was prompted by my learned friend I was about to make precisely that.
Oh, I'm sorry.
And which paragraph does he say that?
That is the punchline of paragraphs 94 and 95.
Right.
And I'll come to that. But that is what he's saying there. It's kind of a fortiori.
Yes, a fortiori.
Yeah. It seems inconceivable that if a decision maker decides to apply a proportionality standard and the Bank Mellat criteria are satisfied, that you could then conceivably succeed on a rationality challenge. Yeah, the last sentence of paragraph 95.
Yeah.
Which I will show you.
We've got it in our brain.
And just to, the final piece in the puzzle in terms of the chronology is the core bundle, pages 129 to 131. There is a notification requirement under the regulations that when someone is designated, reasonable steps have to be taken to notify. This is the letter following the administrative review, and it sets out what the new statement of reasons are.
Which page?
130 of the core bundle.
This is the letter.
This is the letter.
Dear Galia Marti Reserva.
Exactly. And you can see at the bottom of page 130.
So this is the fourth document.
This is the fourth document.
Yes, of three.
Of three. Well, 3 decision-making documents. The fourth document is sending out the decision.
Yeah.
And could not be clearer, it is or has been involved. What the judge has set out in the judgment is entirely correct. Point's never been taken to suggest that it was only is. It's always been it or has. Yeah. That's what all of the documents show. Was never suggested to the judge, when it was a draft judgment, that was an error. point hasn't been taken before. It very clearly is and always has been.
Yeah.
Okay, part 4 of my submissions is proportionality, and I'm just going to very quickly go through the 4 bank mallet factors, but focusing on rational connection because that's really where all of the challenge is targeted. Legitimate aim, there's no dispute between the parties that the objectives pursued by the regulations and by this measure are sufficiently important to limit a fundamental right. That is recorded at paragraph 78 of the judgment. I don't need to spend time on just how important those objectives are, but I will give you, just for your note, paragraphs 170 to 173 of Schwidler, which are relevant to this, because part of these measures are also about what is happening in Ukraine. So no question that designation pursues a legitimate objective of very significant weight. And that is relevant once you get to the fair balance exercise. But it's also relevant, and I'll show you another passage in Schwidler when I get to rational connection. It's also relevant about how direct the rational connection has to be, because the weightier the legitimate objective, the less direct the rational connection needs to be. So, second factor, rational connection. The Secretary of State relies on 6 factors. They're summarised at paragraph 27 of the judgment. They are set out at paragraph 53 of Mr. Darling's witness statement, which is at supplementary bundle, page 103. The judge deals with this issue at paragraphs 79 to 84 of his judgment. We might just take that up if that's convenient. Just invite you to read paragraph 79, which we say chimes entirely with the Supreme Court findings in Schwidler, but also with this court's findings in the Dalston and Schwidler case. It's worth noting that the rational connections relied upon in this case are very similar to those relied upon in the Schwidler case. It was all about incentivising signalling, and you can see that at paragraph 196 of the Schwidler judgment, which is at 1644 of the authorities bundle. The judge was amply satisfied that this requirement was satisfied, and we say he was plainly right to be so satisfied. My learned friend has advanced 2 core objections to this analysis, and they are grounds 2A and 2B of the appeal, and they're really the 2 points, albeit they were largely advanced under the rationality head this morning. They are the 2 key points that she has advanced this morning. So 2A is the allegation that it can't be said that the rational connection analysis, is that the rational connection analysis is premised on a mistaken factual assumption that the appellant has benefited or supported the Government of Belarus, whereas she said, well, that's just not true. And then the second is about civil repression. I'm going to take them in turn, and many of the points I make now will be relevant in the final part of my submissions on rationality. And we say the key, so 2A, the key target of 2A is paragraph 80, and what my learned friend has said is that effectively, by taking the fact that there was acceptance that the appellant was an involved person to mean that that couldn't then get reopened up at the proportionality stage, that was effectively the judge saying, I'm going to ignore all facts. And we say that that is inconsistent with the legislative scheme, but it's also, and this is a point that my Lord made this morning, it's just inconsistent with what bank mallet requires. On this appeal, there is no challenge to the fact that the appellant is an involved person for the purposes of the 2019 regulations, because the appellant has benefited from or supported the Government of Belarus as defined, and there's a very clear definitions, as defined in the regulations. What the question then for this court is whether the imposition of a measure in those circumstances where that criteria has been satisfied is proportionate, because it's rationally connected to the aims of the legislation, there's fair balance, etc. But the starting point must be that this entity falls within the criteria which Parliament has decided, Parliament has decided.
Of course, that's right, but you don't accept, you don't say in Ms. Lester's compelling example about the Gulag,
yes,
you don't say that it is irrelevant to consider the facts at the discretion stage if they are relevant. I mean, there are two things really. The rational connection, well, the Bank-Melat tests do involve some analysis or consideration of the facts, as well as getting over the hurdle. And it's all confused because we're talking about it now in terms of proportionality, whereas actually the argument advanced by Ms. Lester was in terms of discretion.
yes.
But it doesn't really matter. Either way, the first question is, have you got technically over the hurdle to come within the legislation or the regulation? And the answer to that is yes or no. It depends on the words of the statute and the facts that apply to it, and you have to make a decision. Hurdle overcome. You then have to decide if it is appropriate to make a designation, which is very much a decision for government, and if you know that though you've got over the hurdle, the person concerned is sitting in the Gulag, and because they're hotly opposed, they're Mr. Navalny or whoever it may be, you might properly take that into consideration. I'm not saying you wouldn't necessarily make sanctions, other countries don't know, but you could properly take it into consideration. But you say, I think, that they did do all that.
100%. So I agree with.
We see.
I agree with all of that. I agree with all that. But my learned friend.
Sorry, before you go on, can I just ask one question? Ms. Lester said in the course of her submissions that the regulations initially had a requirement that in order to exercise the power, the exercise of the power had to be appropriate.
Yes.
And that was removed. Now, that might be thought to cast light on the nature of the discretion.
Yeah, but we would still accept it has to be kind of Hadfield rational in the sense
yes,
it has
but that may be a slightly different point.
Yes,
but are you able to give us a reference to the unamended version of the regulations, or maybe send one after the hearing?
It was a number of years ago. It was in the Economic Crimes Act that it was removed. So it used to have to show they were an involved person.
Yeah.
And that it was appropriate in light of the objectives, and that was removed as a separate stage. Yeah. But Ms. Lester will still have the point that it still does say may, so there must be some residual.
I understand that, but the removal of the requirement that it be appropriate may cast light on the nature of the residual discretion.
No, I see that.
That's the point I'm rather ineptly getting at.
Back to my Lord's point, I agree with all of that, and that is exactly what we say. All that the court is saying in paragraph 80 is you don't reopen involved person. But if there are relevant facts that go to rational connection, of course the court has to consider those. And of course we have to consider those in relation to exercising the discretion for the purposes of rationality. But that is exactly what the court goes on to do. And I just think, just to give a fair read, it was, my learned friend suggested the court was entirely blind to the facts, and that is just not a fair reading of this judgment. And if I could just take you back, paragraph 71 to 73.
Just a minute, before you leave paragraph 80.
Yeah, of course.
Am I right in reading the end of paragraph 80 to challenge, it's not open to Dharma to challenge the rational connection analysis on the basis that it has not in fact I see invisible inverted commas, obtain such a benefit, unquote, within the meaning of the regulation.
That's all that's being said there. That reflected the submissions that I made.
Sorry, yes, you were.
No, that's fine.
71 to 73.
Because this actually gives some more clarity to precisely that point, my lord. So if you read paragraph 71 and 72, and really the punchline, the end of paragraph, the final sentence of paragraph 72. Para 73, very, very clearly aware, obviously very alive to many first instance judges being criticised for getting the language between rationality and proportionality wrong, and couldn't be clearer. He says about 9 times in this judgment, I am doing this for myself. He says that at paragraph 73. Yeah. That is the lead up to paragraph 80. And then the proof in the pudding, my learned friend's key objection, key factual point under 2A is about, well, the gun to the head point. And that is dealt with factually in detail from paragraphs 82 onwards. In detail. And the judge gives 3 reasons. My learned friend didn't spend any time on this, and the 3 reasons that are given there as to why that does not undermine the rational connection. Reason 1, the factual premise is flawed because it was argued below, well, this shows that we're hostile. And the evidence, and you don't have it before you, there were detailed expert reports on Belarusian law, etc. The evidence showed that actually these hostile measures were being imposed on all foreign companies, about 2,000 or so. It wasn't targeting this individual company. So the factual premise was wrong. That was point 1. The second point, 82.2, is that even if they had been singled out, all of the rational connections that we had relied upon still held good in any event. And then 83.3, the point that it would be perverse and undermine the statutory scheme if the mere fact that a foreign state imposed tit-for-tat sanctions meant that the UK legal sanctions were deprived of a legal basis. So,
jail fee.
Yeah. So the suggestion that the facts were not dealt with, we say, is just unsustainable. That's not what's happened at all. Now, the second objection, this is 2B, suffers from precisely the same problem. So paragraph 81, it's the same point. All it is saying is you cannot reopen. Here it wasn't a concession that they were an involved person. Here they did actually argue at first instance that they were not an involved person and that this criteria was not satisfied in relation to the repression. And that's what was dealt with earlier in the judgment from paragraph 29. And you see under the heading is done an involved person. So what's being dealt with, the 29 is explaining some history because it actually was not clear on the pleadings that this was challenged. It came up at the hearing. We were all very surprised, but I didn't object to the point being run, and that's why it was determined. So this argument was run, and so there's therefore a very detailed factual analysis, 30, 31, 32, 33, 34, 35, 36, 37, 38, as to why this point, my learned friend's key point today about, oh, well, as soon as the IOC came out with a decision, we took steps to terminate our sponsorship, why that wasn't sufficient to mean that they weren't an involved person. And then the judge cross-refers back to that later. And the key reason is that it was just too little too late, because this repression had been happening for a significant period of time prior to the IOC finding, and the judge held, And there's been no challenge. This is not part of this appeal. There is no challenge to the conclusion that they are an involved person. So again, those matters have been dealt with at length in the judgment. They are findings of fact, and there is no basis to challenge those findings of fact. And we say that provides a complete answer to the second objection. So that's rational connection, and that's 2A and 2B. Less intrusive measures wasn't dealt with at all orally. It's dealt with quite briefly in the skeleton argument. We say 85 of the judgment is correct, but if you need more, paragraph 203 of Schvidler provides a complete answer to any suggestion that there are less intrusive measures in a context such as this. Fair balance was also not dealt with orally. It's dealt with very briefly in the skeleton. Our key point is the one made by my Lord Justice Bean earlier. It would be quite extraordinary if there was no fair balance in this case, where there are no assets in the jurisdiction, in circumstances where in all of the other sanctions cases so far, where there were far more significant interests at play. So Schvidler, British national, where the sanctions followed him all around the world because he's a national, so it affected all of his assets wherever they're held. Mrs. Khan, who was residing in the UK, the Dalston case, big giant yacht held at Canary Wharf. The court had no hesitation in any of those cases finding fair balance. The appellant relies very heavily on the impact of the Belarusian measures. Well, that's totally irrelevant because that is not as a result of these sanctions. And the final point is obviously fair balance is something that we're entitled to a certain degree of deference in relation to. So that's heading 4, that's proportionality, which I hope has responded quite fully to the points in the skeleton argument. That then just leaves rationality. I have 5 relatively short points. The first is, and I think I've already done this, is that we accept entirely, perhaps subject to the point made by my lady, that the removal of that requirement may give some insight into what level of discretion remains. But we do accept, and we accepted below, that this is a discretionary power and that it must be exercised rationally. Entirely accept that. We don't accept, and this is the second point, that requires, and again I've been through this with my lord, that requires us to ask specifically in a box in the sanctions designation form, is this decision rational? That's just not how decision making works. What the court needs to look at is all of the reasons, and we say that necessarily will include the reasons that we've said the decision was proportionate, a fortiori. The third point is that we say that is entirely how Mr. Justice Saini understood it on a fair reading of his judgment. So, and that's where we come to 94 to 95, and we say that my learned friend has not come close to identifying any error of law in these 2 paragraphs. And I just ask you to read closely paragraph 94, which is at page 104 and 105 of the core bundle. And I really emphasise halfway through the paragraph that what remains couldn't be clearer, that he recognised there was these two stages, gateway and then a remaining residual discretion. And then we get to paragraph 95, which is, and yes, it's short, but it's short because so much of the analysis was early. And again, I'd invite the court to have a quick look at some point at the skeleton below. It was exactly the same. 1 paragraph on rationality at the end. So it's entirely unsurprising. The use of the word parasitic, he's not suggesting there that this is parasitic on the fact that involved person has been satisfied. That's not what he's saying. He's just saying that it flows from all of the arguments, and that's because the skeleton argument again said this is irrational for all of the reasons set out above. That's all that's being said there. And there is an obvious connection between the rational connection limb of proportionality, bank malus, and an analysis of whether something is rational. And that's exactly what he says here. The arguments made in relation to rational connection aspects of the proportionality analysis, that's what he means when he says it's parasitic. The penultimate sentence of this that is key. It is hard to see how a decision which the court itself, much higher threshold, you're looking at yourself, has found to be proportionate, applying a more exacting test, that's also obviously right, could be irrational under conventional public law principles. Well, if my learned friend is suggesting that that is wrong in law, well, that is just a wrong-headed submission. And I'm not sure if that is the position, but that is plainly right. There is no error of law in that paragraph. And for all of those reasons, we say that the rationality ground of challenge also fails. I'm going to hand over now to Mr. Kapoor, who's going to address there with two separate points on arbitrariness and retrospectivity.
Yes, very good.
My lords, my lady, I'll be dealing with grounds 2C and 2D, which concern retrospectivity and arbitrariness respectively. And those are dealt with in the appellant's skeleton argument, but were not developed significantly orally, so I propose to take them relatively briefly. Starting, if I may, then with retrospectivity. The contention is that the Secretary of State was, quote, not lawfully entitled to justify the imposition of restrictive measures by reference to a wish to signal the Secretary of State's retrospective disapproval of the appellant previously having engaged in lawful conduct. Now, it's important to be clear about precisely what the contours of this submission are. What there is not is any Article 7 challenge to the effect of unlawful punishment. And instead, the allegation appears to be that for the purposes of the rational connection limb of the proportionality analysis, the Secretary of State was not entitled to rely on signalling and incentive effects, which relate to conduct that predated the introduction of the relevant designation criteria under the 29 regulations. And I have 2 points to make in relation to that submission. The first is that the judge was correct to hold paragraph 93 of his judgment, that's at page 104 of the bundle, that retrospectivity is built into the statutory regime and has been authorized by primary legislation, to which I add there's no challenge to that legislation either. I don't at this stage invite your lordships and your ladyship to turn it up, but a similar complaint of impermissible retrospectivity was advanced and rejected in Schwidler, para 201, which is at page 1645 of the authorities bundle, where the court observed that it's inherent in the legislative framework that designation can relate to past conduct. Might be helpful just to take a moment to explain why that is. Now the court's already seen and been taken to Regulation 6, which sets out the designation criteria and in no uncertain terms is expressly backward-looking, is or has been. We've had a lot of discussion about that wording. But what's crucial to note is that that language reflects the enabling provision set out in primary legislation. And in particular, if you pick up the authorities bundle at page 1683, that's section 11 of SAMLA. Section 1 of SAMLA confers on the Secretary of State the power to make sanctions regulations for certain specified persons. And if you see section 11.3, that provides that the regulations must provide that an involved person means a person who is or has been involved in an activity specified in the regulations. What that means is that at the point of introduction, any sanctions regulations will allow for the designation of persons on the basis of their involvement in activities which, prior to the introduction of those regulations, would not have given rise to liability to designation. And that reflects Parliament's judgment that the effectiveness of sanctions measures is often premised on their being backward-looking in precisely this way, so as to bring about changes in behavior to achieve the foreign policy objectives of the regime. And I emphasize there's no challenge to that legislative judgment in this case. Now, there may, on the facts in any given case, be a question of judgment and degree about whether some particular conduct is so historic that it deprives the designation of its rationality or proportionality. That's not the allegation here, and we're nowhere near that territory. And my second point under this ground is simply that the submission doesn't really assist the appellant's case in any event. And that's because, in respect of each of the two grounds of designation, the Secretary of State relies on conduct which both predates and postdates the introduction of the relevant designation criteria. So, on obtaining benefit from or supporting the Government of Belarus, Mr. Popjoy has already addressed you on the clear definition within the regulations. This means carrying on business in a sector of strategic significance. Well, that provision was introduced in July 2022, but of course the appellant is still carrying on that business and has done since July 2022 onwards. So that can be established even prospectively if needed. And likewise, the repression of civil society then, well, that was actually present in the regulations as originally introduced and as enforced when commenced in March 2019. The conduct in question we're concerned with critically is that period from the summer of 2020 until December of 2020, which is a period of political repression, which the judge below rightly went through the chronology and analysed the BNOC's effective complicity in relation to that repression. So for those reasons, we say that ground of impermissible retrospectivity goes nowhere. Turning then to 2D and arbitrariness, the appellant advances two seemingly related complaints under this heading. First, at paragraph 55, Dana relies on the absence of a policy governing decisions to designate under the regulations. And second, also at paragraph 55, but sub 3, there's an allegation of effectively arbitrary differential treatment. The way it's put is failing to justify the designation of the appellant and not others who satisfy the same designation criteria. I'll take each of those complaints in turn, starting with policy. Two short points. First is that there's no suggestion that the Secretary of State was under any public law obligation to adopt a policy, or that failure to have such a policy renders the regime or this particular decision unlawful on conventional public law terms. And second, it's now well established that proportionality is an outcome rather than process-oriented assessment, from which it follows that a complaint of disproportionality is either well-founded on the merits or it's not. And an absence of policy doesn't really take matters further one way or another. Indeed, that is the view the Supreme Court took in Schwidler when dismissing an analogous complaint about the absence of a policy on designation or de-designation. That's at para 222 of Schwidler on page 1649. Don't invite you to turn it up now, but I can quote, "The absence of a published policy on designation makes no difference to this analysis," in reference to the proportionality analysis.
222, did you say?
Exactly. Which brings me finally to the irrational inconsistency of treatment. On this point, my overarching submission is that the appellant's reliance on Belmarsh and Bankmelat is just misplaced. And again, the judgment of the Supreme Court in Schwidler is instructive, and indeed we say dispositive, because the appellant in that case mounted a materially identical challenge, which the Supreme Court dismissed. This I would invite you to take up at page 1648 of the authorities. And in particular, the reasoning of paragraphs 218 to 221, which is where the Supreme Court explains why the analysis in Belmarsh and Bankmelat can't simply be read across to a designation decision in this way. And the key passages which I'd invite you to focus in on is the final sentence of 220 and paragraph 221, which explains why the reasoning doesn't apply in Schwidler. And what one takes from the Supreme Court's analysis there is that to establish arbitrariness in the Belmarsh sense, one needs to do two things. First, you need to establish that you're materially similarly situated to the alleged comparator. And second, and crucially, that there's some accepted baseline set of general measures which has been accepted as sufficient to address the risk posed by those comparators, with the consequence that there's no justification for anything further in respect of the appellant. And neither of those premises can be established in this case. So on the question of similarity, the simple point is that the court is just not in a position to assess for itself the nature and extent of various companies' involvement in sectors of strategic significance to the Government of Belarus. You've had two seemingly random construction companies cited to you. There's no evidence about them, about the nature of their business, how significant that business is, how long-standing it's been, and these are judgments that we respectfully submit are quintessentially matters of judgment and evaluation for the Secretary of State, thinking about what are the levers, what are the pressure points by which to influence a foreign government's calculations, and we're simply not in a position to reach any conclusions about similarity in that respect. And so Mr. Justice Saini was right to conclude that the key evidential material to make good an allegation of discrimination was missing in this case. And second, and in any event, even if one was satisfied about the comparator, the insurmountable obstacle here, as in Schwidler, indeed it can be read across directly, is the baseline. There's simply no basis for contending that the non-designation of third parties, whoever they may be, is the result of an assessment that some other general measures will be effective to achieve the public policy goals of the regime. And so the analogy with Bank Melat and Belmarsh, in our respectful submission, simply fails to get off the ground. Yes, I can assist you further.
Thank you very much. Slester.
At first point, the reference to the removal of appropriateness, just you'll note 14th of March 2022 in the Economic Crime Transparency and Enforcement Act 2022. Thank you very much. A very brief reply from me and then also from Mr. Birdling. Members of the court, the example relating to the person in the gulag is very instructive, because the government's position on this has completely, it seems, shifted, but now seems to us entirely unclear. So the key question is, could it be argued by the person in the gulag that despite still carrying on business in the transport sector, as a matter of fact, he or she is plainly not benefiting from the government because they have been locked up by them? Now the government now say, well, of course you could make that submission and we would take it into account. Can I show you their submissions below on this, and why we say the judge accepted this and was in clear error? The submission made by the Secretary of State, which is at paragraphs 51 and 52 of their skeleton argument below, you will find at page 159 of the supplemental bundle. And the Secretary of State was very clear. The claimant contends that Dana has not benefited from or supported the Government of Belarus. This is unsustainable. Dana hasn't challenged the determination that it is an involved person,
by virtue of having obtained a benefit from or supported the government of Belarus through carrying on business in a sector of strategic significance. So that's the person in the gulag saying, well, plainly I am still on the books as operating in the transport sector. It is not open to the claimant in those circumstances to challenge the Secretary of State's rational connection analysis on the basis that it has not in fact obtained a benefit. Next paragraph, exactly the same in relation to the other ground for designation. So second, the claimant contends it cannot be assumed from the claimant's sponsorship of the National Olympic Committee that it has enabled or facilitated the repression of civil society. This is also wrong. Dana has not challenged the determination that it's an involved person, that's step one, by virtue of having enabled or facilitated repression. It is not open to it to challenge the proportionality analysis on the contrary factual premise. And that is what was accepted by Mr. Justice Saini and what you will see in terms of paragraphs 80 and 81 of the judgment. And that is why our submission has been that the error here has been to take that deeming provision, as we've called it, which defines the condition A, I'm not going to go back to the regulations, but I'm sure the court will, and to give that far more significance at step 2 than it is designed to have in the matter of the regulations. It's a simple matter of construction, but they absolutely are saying below, and that submission was accepted by the judge, that once you are an involved person, you may not argue the contrary. As a factual matter, you may not say, actually I'm in a gulag and therefore it's absurd to suggest that I am not benefiting from the government. That is exactly the argument that was made, and it's exactly the argument that was accepted. And that's why we say this is a very serious error by the judge. And if it isn't corrected, that will be carried through into every subsequent sanctions designation decision. Now, my learned friend then says, well, actually it doesn't matter because everything was gone through in the factual analysis sections of the decision-making documents. But as I hope the court will see, when you actually look at the substance of those documents, that is simply not correct. It's all very well to wave through the number of pages and paragraphs, but the key issue is, were the centrally relevant matters of fact actually considered by the Secretary of State? And they're simply not there. Take as one example, the Olympic sponsorship agreement. There is nothing in the analysis that Mr. Pobjoy showed you, and nothing in the paragraphs he didn't show you, about the key point that Dana Astra, as soon as it was aware that allegations were being made about the Olympic Committee, that it sought to terminate the agreement straight away. And what more could it do? And indeed that its workers were anti-Lukashenko and permitted to strike. Now, the extraordinary submission today is, well, that was too little too late, and that was the government's reasoning. You will find that nowhere in the decision-making document.
Can I ask you, sorry to interrupt, Ms. Les, can I ask you a question about this part of your submissions? Would you accept that the finding the facts on which the designation is based and on which the discretion is exercised is a matter for the Secretary of State, and he or she is not obliged to accept the factual points that are made by your client in the submissions?
Not obliged to accept factual points, but the Secretary of State has to act reasonably. So if the Secretary of State's unclear on a key point, as I have shown you that the Secretary of State was, the obligation is to clarify that, for example, and to act reasonably in considering whether submissions are being accepted or rejected.
Right.
There's normal public law constraints on decision making. So this is my final point, the too little too late point. When the sponsorship agreement was entered into, and that's why I was careful to say this, President Lukashenko wasn't designated. The facts before the Secretary of State, which were not contested, showed that this was an agreement regulated by the International Olympic Committee on normal terms. There is no suggestion at all that that was an improper thing to have done. Now, the first concern expressed about repression, sanctions had previously been lifted on the Lukashenko regime. The first concern that was expressed about repression was in the aftermath to that August 2020 elections. Complaints were made in September and October. In October there was an investigation, and in December there were the provisional findings. So that is the factual position. There is no contest about that. And as soon as Dana Astra saw that those provisional measures, it sought to distance itself as quickly as it could. That is the factual position. It's simply not open to the Secretary of State to come to court today and on their feet make up a new rational justification for that being a proper way to sanction my client.
Is it relevant that Dana Astra is apparently the only non-state body to sponsor BNOC?
No, well, that's not quite correct, my lord, because there are different categories of sponsorship. There's a lot of evidence on this. So it's not the only non-state sponsor of the Olympic Committee. The point being made was within the category of sponsorship, it was the only one in that category. But no, the key point we say is, yes, it was a sponsor, nothing improper about that. Sponsorship on commercial terms, no one suggesting otherwise. And as soon as there was a glimmer of concern about repression, it distanced itself and supported its workers in anti-Lukashenko strikes. Now, although rationality is a high threshold, to suggest in those circumstances that my client was complicit in the repression of democracy, which is a pretty tough thing to say about a company, has to be based on proper reasoning, not with someone coming to court today and suggesting for the first time that there was a problem with it from the beginning. And those key points, those key factors, central to the analysis are simply nowhere in those documents. Thank you.
Yes, Mr.
Just very briefly on jurisdiction. What Sir James did in my submission in his response was to glide over what is perhaps the most critical distinction that the court was making in EMN. Because all of the decisions that he took you to, the court was dealing with the same core set of principles. And when one stands back and considers what sanctions are, we are here talking about targeted economic sanctions over individuals. And they are an extraordinary and very recent development in state exercise of jurisdiction. It's not like traditional sanctions that have been a feature of interstate relationship for really centuries, where a state blockades another state and says you can't trade oil from a particular jurisdiction. If you're a company that was affected by that was abroad, then one can see exactly how that would be a traditional effects case. It's a decision that's being made in one jurisdiction that is going to have effects in another. Now that is not sufficient. We know that's not sufficient, and that's not how we put our case below, and it's not how I put my case this morning. What is material here, and what brings this within the category of cases that the court was dealing with in NN, and the exceptional category of cases? I don't shy away from that, and I say sanctions, individual targeted sanctions, are an exceptional exercise of state jurisdiction, is that they are imposing sanctions on an individual person. They are exerting authority and control over that person. It's the over them that's critical. For all of the reasons that the court was at pains to point out in the cases that Sir James took you to. And when Sir James suggested the door was closed, what he skated over was paragraph 107, the critical paragraph. It is critical. And what Sir James said is that it's unsurprising in those cases, clear and constant jurisprudence that the Grand Chamber cited both in and the other cases, is that in those cases, in those situations, the state was instituting proceedings, doing something of its own volition, involving a person, exercising its jurisdiction over that person. And Sir James said, well, in those circumstances, it's quite unsurprising if you institute a proceeding in your court involving a person, even if they're abroad. It's unsurprising that they have Article 6 rights. It is unsurprising. The reason it's unsurprising is because that state is exercising its jurisdiction over that person. The person's abroad, but that is not material. The distinction is, what is the state doing in respect of an individual? Are they exercising authority over them? That's the difference. My case is not an effects-based case. We know crystal clear from MN and their subsequent cases, including the environmental cases, that that's not enough, but that is not this case. And the next point that really follows on from this is that Sir James said, well, actually, in answer to a question from my Lord the Master of the Rolls, we don't even know what Strasbourg would say if you had a case that involved property of an individual that was outside the jurisdiction, that was within the jurisdiction. Difficulty with that is we know precisely what Strasbourg says, the Grand Chamber says. In that situation, that's the Vida United Kingdom case I took you to. And I'd ask you to read the passage that I took you to that Sir James didn't respond to, paragraph 93, very carefully. Because it says precisely that. When a state is exercising its jurisdiction over the property of an individual within the jurisdiction, even if the individual is outside the jurisdiction, that is an exercise that is within, that brings that individual within Article 1 of the Convention for that purpose. So, just like if what you're dealing with is the state instituting proceedings over an individual, yes, the relevant right that they have that's in play is Article 6, Sir James says that's not surprising. If it's property that you're concerned with, here, the goodwill of a business, that is, in my submission, a worldwide concept. It is the analogue of the Article 8 interests of an individual, and this is how the court, we have to argue by analogy because of the absence of cases dealing with sanctions. But in an Article 8 case, an individual's reputation is something that is with it wherever it is in the world. So even if it's physically outside, these were the cases that the court was dealing with in paragraph 93 of VIDA. An individual outside the jurisdiction's Article 8 interests in its reputation will still be within a state's jurisdiction if a newspaper publishes pictures of them, invasive pictures of them within the jurisdiction. And that is the responsibility of the state in that jurisdiction. That is how the convention works. And I would ask you again to read paragraph 93 of the Vida United Kingdom judgment quite carefully, and also look at paragraph 77. That was a case involving the United Kingdom. See the submission that was made to the Strasbourg court there, very similar to the submission, obviously not concerning sanctions, but concerning the points that Sir James was making about how far Strasbourg has and has not been prepared to go. And you see at paragraph 93 very clearly what the court's answer to that was. And Sir James didn't attempt to answer that at all. Next point isn't on jurisdiction, it's on a point that Mr. Pobjoy raised, and it was about the is or has carried on business. And with respect, what Mr. Pobjoy's submission does is to miss the point. The point is not, did the Secretary of State's reasoning consist in part of an allegation that my client had in the past carried on business? Obviously it had. But what Secretary of State didn't do is say, I consider that the fact that the Astra has in the past carried on business is the reason why I'm going to designate it, or that's the basis on which I think it's appropriate to do so. What the Secretary of State said is, I conclude that Astra is and has. And it's the is, when you read through the reasoning, is continuing on an ongoing basis to obtain a benefit from the government of Belarus because it is carrying on business, is central to the reasoning. So it's not that they get home because they can say, well, on any event, at some point in the past year, that's not the basis on which the Secretary of State made the decision. If it was, you'd be looking at a very different decision, and you'd be dealing with a very different challenge. But when one is dealing with a rationality challenge, what the court has to do is look at that and say, was it actually a rational part of the Secretary of State's reasoning to to say, actually, I think on an ongoing basis, go back to my learned leader's gulag analogy, you still continue on an ongoing basis to benefit from the government of this rogue jurisdiction because you at some point in the past did. You need to look at the reasoning that the government is actually putting forward and asking the court to frank as being rational and lawful. And the reasoning that they have put forward is, as Ms. Lester said, reasoning that is, in this context, materially, that you are obtaining an ongoing benefit from the government, when the facts before it were patently in the opposite direction. And in answer to my lady, Lady Justice Laing's question, is it for the Secretary of State to make those facts? Well, in a rationality context, obviously the fact-finding is primarily for the Secretary of State, subject to rationality. You've got to consider the material before you. Elementary fairness requires that you have the opportunity to make representations. That's why it's not open to the government to come up to the court today and come up with some new argument, some new reasons. You've got to say, this is the case. You have the opportunity to meet it. The Secretary of State either accepts it or they don't. But then you get reasons. And it's for the court to ask, do they stack up or do they not stack up? In our case, they don't stack up. So, my lords, my lady, unless I can assist you further, they are my submissions.
Thank you very much, Mr. Berlin. Well, that looks like it concludes the hearing. We will take time to consider our judgments in this case. When we hand them down, will you please make any typographical corrections and agree an order and costs? The case is probably sensitive and we may give you very little time to give us corrections, but we'll give you a bit longer to agree the order and costs. And I think we'll make sure that you know when it's coming so that you can have somebody available to deal with the corrections. Because I don't like giving lengthy periods of time for draft judgments in case they're misused or misunderstood. So that concludes it. Thank you very much to counsel and solicitors. An interesting hearing, and we'll get your judgments as soon as we can.
What about April?